Morning, everybody. Thanks, Lorraine. Really excited to have Law Forward here today. The Defend Democracy group thought this would be good timing with the fall coming up real fast and the election litigation season kicking off. So Law Forward's been super effective. They're pretty new, but they are throwing themselves into a lot of fights and winning a lot of them. TR's here. He's a Marquette grad, law school grad, and he's going to run through what some of the upcoming issues are. So let's welcome him.
Thank you. Thank you. First, a point of order from Dave. The election litigation season never ends because we live in a state where elections never end. So I want to first start there. So again, my name is TR Edwards. I'm one of 5 staff counsel at Law Forward. Law Forward is a nonpartisan, pro-democracy, nonprofit law firm based in Madison, Wisconsin. We were founded in 2021, just after the 2020 election, for anybody who was wondering. And we have primarily focused on defending the concept and idea and the exercise of democracy. We also focus pretty considerably on holding bad actors accountable as well. In this presentation, I want to share a bit about kind of our seminal cases, the fair maps and fake electors, but also share the work we have been doing outside of that, including ballot access and election protection. And then lastly, if we have time, I was hoping to kind of engage in a discussion about future threats in the pro-democracy space. I'm hoping I can make this as much of a conversation as possible. I don't particularly believe in or like lectures. So if you have a question, ask it. I'm here for the work of democracy, and I want everyone's voice to be a part of that. So who are we? As mentioned, we engage in strategic litigation, often engaging with co-counsel from all over the country. We attempt to marshal and corral those resources to get the best outcome for Wisconsin residents. We center Wisconsin in our work. We believe that that makes us both unique, but gives us really a distinction from other actors in this space. So again, what do we do? Strategic litigation makes long-term systemic change that caters to Wisconsin needs. Rather than fighting just individual cases, taking plaintiffs on an individual basis, we attempt to organize groups of plaintiffs to make sweeping change that affects the entire democracy space in Wisconsin. Law Forward wants to guide the law's evolution so that Wisconsin's democracy is strengthened as a result. So why we do what we do? Unfortunately, in our Constitution, for those who haven't read it recently, there is no affirmative right to vote in the Constitution. Our state constitution is a distinction because we actually do make sure that that is explicit, but in our US Constitution, that isn't in there. Our Constitution in many ways was not actually designed with the ambition of fostering the participation of all people. In fact, the primary concern of many of the founders was to explicitly curtail the excesses of democracy, as James Madison said. Their goal was to protect the moneyed and propertied interest from what they saw as a public that was want for destruction. That is why we have an equal Senate, each state having 2 representatives, no matter if their population is 400,000 or 45 million. That is the reason why we have an electoral college. That is why for nearly the first 200 years of our nation's history, only white male property owners over a certain age were guaranteed the right to vote. Thankfully, many of these have changed, including our own Constitution, which has now been amended 27 times, with that 26th Amendment being to grant 18-year-olds who, as you can see throughout the country, are experiencing their own challenges with democracy, will have the right to vote as well. So, as Dave mentioned, Law Forward is relatively new. Again, I mentioned that we were founded in 2021, but in those 3.5 years, we've had a lot of success. Again, like I said, we don't focus on individual clients. We try to make strategic choices that impact the broader democracy. And in that time, we've won 29 cases. It might actually be more than that. I probably need to update.
Yeah, your website says 32.
So there you go. We partner with more than 25 organizations, filed almost over 10, I think we're actually at a dozen now, amicus briefs, and published 12 reports. And we protected the rights of about 6 million people. So before we kind of get into that specific conversation about those two major cases, I want to both show this picture, but also ask the question to folks in the room: what does democracy mean to you? Before I get into those cases, I think this is important to show because, as I mentioned, at our founding, we had a very different idea of what democracy was. So before I give kind of my beliefs, anybody in the room want to share what democracy means to them? That
Government of, by, and for the people.
Majority rule.
Participation of citizens in the democratic.
Anybody else? I think that's a good start. I will say for me, it's everything and, right? It's the idea that we should all have some aspect or say in the functions of the systems that govern us. That is a system that I think more people can buy into. I think that's a system that is more prepared to exist over the long term, and one that, God willing, will have the least tendency to oppress the people served by it. Because unfortunately, we've seen that in other countries in particular, the systems that are in place, autocracies, oligarchies, whatever else have you, kleptocracies, without strong controls in place, collapse and collapse upon the people the most marginalized and most at risk. So if we're going to truly have a representative democracy, we need to express the full rights of every single person that exists within it. So majority rule is important, but so is the protection of the minority. So how do we achieve that? What is that balance? Thankfully, we have some principles both in our state and in our U.S. and as well as our state constitution that have allowed us at Law Forward, as well as other attorneys from across the country, to continue to work on building that representative democracy. So going back a little bit, so I've been involved in or working in politics since I first knocked on doors with my mother in 1992, right? So at some level, I've experienced the different stages of what democracy can look like, whether it was knocking doors, having house meetings during the Obama campaign. I have been involved in this work. This work has been central to everything that I have become as a man and hopefully as a father and husband. But one of those linchpins, those turning points, was 2011, right? At the time, I had just left working at Senator Taylor's office, now Judge Taylor's office. And I went back to labor with the hope of trying to bridge a gap with our governor at the time, Scott Walker. Little did we know, he had a much bigger plan in place. That plan ended up leading me to spending 6 weeks in the Capitol. But what we didn't know was that behind the scenes, they were working on something far more insidious, something that would change every single thing that we hold dear as a laboratory of democracy, as Theodore Roosevelt called it, in Wisconsin. Right across the street from the Capitol that I was staying in, the Republican legislators walked into office at Michael Beston Friedrich and crafted the most enduring and significant gerrymander in our country, led in part by Operation Red Map and the Republican State Democratic Leadership or Elections Committee, forced all of those representatives to sign NDAs. Mind you, these are people that are being paid by the government, using government resources to pay this firm. But at that time, they signed NDAs that prevented us from knowing the exact details of the conversation. But for those of you that haven't read it yet, I have this book up on here for a reason. Minority Rule, the first chapter of this book, to show you how important Wisconsin is, the first chapter of this book by Ari Berman explicitly details what happened here in Wisconsin, both that interplay that I just mentioned, as well as those changes in how democracy would function during the course of during the course of his governorship, including 33 different laws that changed the way that people vote in our state. So I say all that to say as kind of a foreground for a discussion of our our fair maps case, Clark versus Weck. In Clark versus Weck, we had 19 individual plaintiffs representing a cross-section of Wisconsinites from all over the state in various different geographies, representing different identities, and also that represented the different claims that we were making. Our defendants originally were strictly the government. We went after Wisconsin Elections Commission, but after some legal finagling, we ended up having 7 total parties in the case, including 3 defendant groups, as well as 4 different plaintiff groups. Our claims, the first one was pretty simple. We both believed that we had evidence of and were able to prove that there was a rampant scheme of partisan gerrymandering in our state, and that partisan gerrymandering, not because we represent Democrats or Republicans, disenfranchised in one way, shape, or form a good percentage of the state from having a say in how their state functioned. Even in 2012, when President Obama won this state by almost 4%, there was still a 61 to 38 representation in the state house or state assembly. The second was separation of powers. We believe that by making the maps that were proposed by the state legislature the law, which is what the Supreme Court did in Wisconsin and Weck versus Johnson, that they were in violation of our Constitution, our state constitution's grant of separation of powers between the different branches of government. Finally, and arguably in this situation, most importantly, we found that our maps were incontiguous. As you can see in this map here, it's a simple representation of how our maps had roughly 2,000 or so islands that were separated across or away from their larger bodies, their actual assembly districts or Senate districts. Wisconsin Constitution requires that all districts be contiguous, meaning they cannot be made up of separate pieces of detached territory. So while that may seem esoteric, our Constitution requires it, and as such, we should follow that. These are a couple more examples of what the non-contiguities look like. I think it's also worth mentioning that in our research, we found that we are only one of, before this changed, we were one of, I believe, 5 states that had any contiguities. But the total number of incontiguities throughout the nation, outside of Wisconsin, was 6. As I mentioned before, we had over 2,000 different pieces of detached territory spread through our state. Now, mind you, this happened through legal machinations of government, annexations, cities or counties splitting apart for one reason or another, things that happen legally and are perfectly understandable. But no matter what, our Constitution requires that those districts be contiguous. What we learned through the process of formulating potential remedies was that not only was it possible to do, you could do it while also ensuring that the other mandates within our state constitution were affirmed and protected as well. So a little bit about what happened during that case. Again, as mentioned, we filed on August 4th. August 15th, the Supreme Court issued a scheduling order. There was a lot of back and forth rigmarole in terms of the process and procedures, but a couple of key things happened that I think are worth mentioning. As most of you know, in April of last year, Justice Janet Protasiewicz was elected to the state Supreme Court, giving for the first time in many years a quote unquote liberal majority on the court. And while that can matter politically, what it meant to us organizationally was that for the first time in quite a while, there's a court that is willing to listen to valid arguments. That is what we look for in state Supreme Court justices or any level of the court? Will the person that is elected, the person that is put in position, listen to valid arguments and make reasoned opinions? God willing, that'll continue to be the case. Those elections will continue to be important. If I had my way, we would not be electing judges, but in the time that we do, we hope that the average individual that is voting in those elections understands that the question, the foremost question that we ask of justices is, will they listen? If you got that answer, no matter almost regardless of where they stand on the political spectrum, you can work with them. That's what we believe as attorneys and why we continue to do the work that we're doing. But because of that election and some of the statements made throughout, there were petitions. There was a petition filed for her recusal. There were also threats of impeachment. A lot of what happened behind the scenes is not what we should see in a democracy. And I think it's important to hold those responsible to account, but that's neither here nor there. As I mentioned, there were various different things that happened. One of the awesome experiences that I got to be a part of was oral arguments before the Supreme Court. That was my first time actually doing that. So actually being present for that. We had oral arguments in front of the Supreme Court. And as the person who actually argued, Mark Gaber, as he stepped up to the podium and to the mic, he got that long before he got attacked. It was an incredible experience to watch, but he handled it well. And I think the court was responsive to the arguments that we made, both through our briefing that I got to be a part of, as well as the arguments that were made at oral argument. So after the decision was made just before Christmas that our current maps were unconstitutional, we were hearing rumblings about potential legislative proposals that would either invalidate our work or, God willing, support the effort to have fair maps in our state. A little after that decision was rendered that got rid of those Act 43 maps that were instituted in 2022 by the state Supreme Court, on January 30th, the governor vetoed the proposal of his Maps Plus. Now, why? It's hard to say exactly why. I'm not the governor, but what happened with those maps, as far as I could tell, there were shifts made to protect incumbents as well as protect a few more quote unquote Republican seats. For one reason or another, the proposal was vetoed, but that left the door open for a bipartisan legislative solution, which, to be clear, even as an attorney, my hope always is a bipartisan legislative solution. That is the one that typically is the most enduring and the one that gives the best opportunity for the people at large to have a voice. February 13th, after some consternation within the Democratic and Republican caucuses, the governor's maps proposal without those prior amendments was passed. February 19th, Governor Evers signs those maps, and in the most egregious partisan gerrymander in the country. There are still some outstanding lingering questions there. First and foremost, as we've seen through some interesting things happening in the Racine area, what maps govern recalls and special elections? We recently had 2 legislators who have become judges. So now what happens with those seats? What maps are in place for those? Because one of the things I didn't mention about those February 19th maps, they were declared effective in November. So that meant in that interim time between February 19th and November, we are a state without maps. Those old maps are enjoined, meaning they are foreclosed from use in elections, as well as in the steps leading up to elections, like gathering signatures for a recall. The next thing that we have to decide and decipher is whether or not the protections enshrined in both that February 19th decision or February 19th legislation and the litigation that happened prior to that, whether or not that is enough to ensure that there will not be another partisan gerrymander in the future. I'll give everybody here one guess, the likelihood of that. So as you can imagine, I am a firm believer that our work is not done. I am a firm believer that while we stand at the precipice of potentially having either a constitutional amendment or legislation in place that gives some dictate of what a nonpartisan MAPS commission can look like in the future, it is by no means a guarantee. If neither the makeup of the legislature changes or the disposition of the people sitting in the legislature changes, it's a high likelihood that's, in a little bit over 6 months, that we could, well, I guess they wouldn't be invested until January, but we could be in a situation where we are right back to fighting a gerrymander again, where we are right back to having to beg for fair maps. And I don't think that is really what the Wisconsin idea is about. While I mentioned the fraught nature of some of the initial arguments around our US Constitution, our state constitution was founded with the principle of egalitarianism at its core. We have to continue to protect that. We have to continue to ensure that is the ideal and not just that is an idea, that is in place and not just an ideal going forward. So the hope is we will continue with this process, having good conversations with citizens as well as legislators to make sure that we have a permanent solution going forward. Or maybe we'll have to file another lawsuit. Next, I mentioned that the next part of our work, and frankly, it was happening largely at the same time as this, so I didn't get to work as closely on this as I did with the Fair Maps case, but was our fake electors work. So for those of you that are unfamiliar, I can't imagine how you would be, but in 2020, there was a group of false electors that gathered at our state capitol on the day declared by the Constitution that submitted fake electors in support of the failed candidate. Those individuals were 10 different citizens as well as 2 Trump lawyers who helped kind of put together the scheme nationally. In many states, those people have been held to account criminally, but unfortunately, for one reason or another, our state DOJ didn't see that as the right path. So in 2022, Law Forward and a group of his clients filed a lawsuit against the Wisconsin fake electors. This case is called Pennebaker. In this case, we partnered with Stafford Rosenbaum, represented by our co-founder, Jeffrey Mandel, as well as ICAP, which is basically what we are, but at the Georgetown University Law Center. On March 4th, we reached a settlement with the last of the defendants, the Trump lawyers, Kenneth Chesbro and Jim Trupis. In that settlement, we were able to get more than 1,400 pages of documents, emails, and text messages, along with photos and video offering a detailed account of the scheme in Wisconsin, the scheme's origins in Wisconsin. Now, why that's important isn't just to embarrass those attorneys, embarrass the Trump campaign. No, it's a lot more, it's deeper than that. In my opinion, first and foremost, bad actors, regardless of what crime they commit, need to be held account for what they do. But more importantly, we want to make sure that this doesn't happen again. If Vice President Pence takes a different tack, we're in a different world. We are in one where the one guarantee that we had in our Constitution, a proper transition of power from one party to the next, could have went away. Doesn't mean President Biden wouldn't eventually become president, but the process that we would have went through to get there could have been worse than what happened on January 6th. So as insidious and invidious as the work that happened by these attorneys, what we also were apt to guard against was what the next thing is. Because the people that are anti-democracy are not done. They will come back. They will have another scheme. We don't necessarily know what it'll be. We spent some time gaming out the possibilities. We don't necessarily know what those will be, but they need to know that whether it's 2 years later, 4 years later, in this case, they'll still be held to account for their bad actions. So God willing, that acts as some reasonable level of deterrent against future crimes against our state. Further accountability work. We have our good friends, former Justice Gableman and Bob Spindell, who is one of our state elections commissioners, who few months ago declared that he has done more for Black Americans than any Republican in history. There's one that I can think of that might have done a little bit more, but to be fair, if that's his belief, so be it. Justice Gableman is the person who was responsible for a lot of bad things, but one of the most recent was that he was the person in charge of the checking election integrity task force, basically robbing the state while coming up with BS lies to try to enrich himself. Bob Spindell, again, was one of the fake electors, but also just in general has been anti-democracy in general as part of the commission. So we've worked with various different community organizations to see both Justice Gableman held to account through an OLR complaint, which is the Office of Lawyer Regulation. So getting him sanctioned, for his work, if you can call it that, as well as Mr. Spindell working with those same groups to get him to hopefully step down from the commission, as his anti-democracy efforts are the antithesis of what the commission's work should be. Another key part of our work continues to be ballot access and election integrity. I got to spend this year in our quote unquote election protection war room, where different organizations of pro-democracy attorneys, both in the state and outside of the state, kind of come together to be kind of a clearinghouse for issues as they come in. So like if you see different inspectors or people there doing poll watching, a lot of that information gets filtered back to us to ensure that what's happening is on the up and up and legal, but then secondarily, if some type of immediate emergency action needs to be taken, us or someone at the table will be able to step in and try to get an injunction or get some type of performance. A good example of that would be, we actually didn't do this. I give a lot of credit and kudos to the city attorney of Madison, but an example of that type of work was in Madison. So at the bookstore polling site, someone had removed signs. So people didn't know that they were able to vote at the place for about 2 hours. Now, in this instance, if there had been an individual voter who had reported to us that they were not able to vote because of that, we probably would have filed a lawsuit. But because of how standing works, the city attorney is able to stand in for that person, and they were able to get an extension of polling hours at that specific across the entire city in response to whatever that bad actor did or why they did it. These types of low-tech challenges to democracy could be a new wave. Now, we also have the high-tech wave around AI, which I continue to have my head unraveled by. But these types of low-tech challenges to democracy are likely to continue. So we encourage every person that we speak to just be on the lookout for these things, whether it's people taking down signs, people putting up fake roadblocks. There are things that we have seen here and in other states of low-tech forms of voter suppression that continue to proliferate. And unfortunately, because of their nature, can be hard to capture as an organization, but we need individuals really to kind of be on the lookout for that. Also, in terms of ballot access, one example of that work was the rights of students. So in 2022, I believe, there was a challenge. There was a challenge made by a lady out in La Crosse who believed that her vote was diluted because of the votes of the students in her district. Now, again, as I mentioned, the 26th Amendment kind of gives them the right to do that. So, but her belief was that her right was diluted because these students who she believed were ill-informed or not as concerned about the district that they spent 4 years of their lives in, didn't have a right to vote. So we participated in that, and thankfully we won. And those students' rights continue to be protected. That sheriff that was elected there continues to be in office. And that, again, is just an example of the types of anti-democracy litigation that will continue to propagate and pop up. So we want to continue to be vigilant and on the lookout for that type of stuff. As I mentioned earlier, how integral our partners are. Both everybody in this room, sorry to tell you, you are now partners in our pro-democracy work. But a couple of our institutional partners, whether it's BLOC, which is the Black Leaders Organizing for Communities, as I mentioned, ICAP, the Institute for Constitutional Advocacy and Protection, Disability Rights Wisconsin, the League of Women Voters, the Election Law Clinic. These are partners that have either acted as clients, acted as supporters and people who gave us information, or in the case of the Election Law Clinic, co-counsel on some of our key litigation. They will continue to help us as we build a platform, a pro-democracy agenda, as well as a plan for ensuring fair and equal representation in our democracy. Again, as I mentioned earlier, I do not believe we have a full democracy yet, but we continue to strive to achieve that. And these are also people who just support our voting rights and election protection work. So, as I mentioned before at the beginning in the outset, I was hoping to have a conversation with you all kind of about the future of democracy, or really the future of democracy work in our state. We know who the big players are, who the big players have been on the other side. The Heritage Foundation, ALEC, their proposed plans for 2025 and beyond. Our arch nemesis will, but that is just a part of the picture. I really kind of want to hear where we go from here from the people who actually have experienced democracy.
Just jumping in first, if you just repeat the gist of the question.
Sure.
So and there were a couple of people who had.
Perfect.
You get closer to the microphone.
No problem. Sorry, I should be shorter. So I was hoping we could have a discussion about future threats and opportunities in the pro-democracy space. So I'll give a little bit of a foreground. We know that there is an election this year. It might matter a little bit, so I'd be interested to hear what you guys think might happen. Starting with you, sir.
Yeah, I'm gonna add some context.
Please.
I was an educator for over 20 years. When Scott Walker with Act 10 came into being, I retired. Right now, what I'm doing is rereading the Constitution. But what scares me right now is Marjorie Taylor Greene, Matt Gaetz, Ron Johnson in our own state, and what they are trying to do. And the Republicans have said that they will, regardless of the outcome of the election, they will recognize it. That's scary.
As well as should. Again, as I mentioned earlier, one of the foundational principles in my mind of a fair democracy is a peaceful transition of power. If we erode or eradicate that, we don't have that anymore. So I think that is key. I think it's also important to understand that if our institutions at the state level function properly, both in Wisconsin, again, as a laboratory of democracy, but other states function properly, no matter what they say, be okay. So we have to continue to take these smaller, quote unquote, challenges of ballot access, vote, ensuring that people are able to vote, whether it's because of nefarious reasons and people trying to stop them, or just tactical ones. Like we just recently had a constitutional amendment passed that limits and restricts the ability of local elections clerks to actually find the resources they need, because we do not properly fund elections work in the state, to actually find the money that they need to support the work. We also have challenges to how they do the work. So one of the cases that I'm working on now, we just recently had our petition granted for a case called Brown versus Racine County, which is, in the long story short, the city of Racine, to both make good use of the few and limited resources that they had, decided to decided to pick up or buy a mobile elections unit that would be used to supplement their early vote initiative in 2022, in 2020 and 2022. That was challenged by Will and others on the grounds that they felt that it did not properly operate as a site. So the state Supreme Court will hopefully be hearing arguments from us and others to basically explain why this is both needed. We need more innovations to ensure that more people have access to voting, but also because functionally and operationally, the resources and constraints faced by local elections clerks makes their work more and more difficult. So again, making sure that our state systems are working will ensure that our federal systems are in a better place and have better foreground. Anybody else? I know there's, I'm sorry.
I work at the polls, I've done some. And over the years, there's always been talk of like real efforts to disrupt voting, like intimidating voters.
Yep.
Challenge them all. I'm reading something suggesting that our people who oppose democracy are getting seriously organized, that people in polling places, just challenging a whole bunch of voters, just coming up with works to keep voting occurring. And I don't know if that will come to pass or not. I have not seen that.
Sure.
They come to pass despite concerns about that for many years. Is there a legal angle step that seems very conspiratorial?
Yeah.
To show up in places that are minority or democratic and do everything you can to slow things down.
Yeah, and I'll share something that we learned about that happened in Green Bay that was very similar to what you mentioned, but as opposed, and this is where we kind of face a challenge because at present, there are not protections in place at the same level for individual voters as there are for poll workers or poll watchers. So it seems like an asinine distinction, but it is the one that we operate under. So in Green Bay, going back to that example, there was a poll watcher there who represented the NAACP, in Green Bay, who was there ensuring that people had access to vote and had all the information or whatever they needed to actually be able to go to the polls. Well, this young lady, again in Green Bay, had a person in a pickup truck driving around hurling slurs at her, threatening her, and basically just trying to scare her away from doing the good work that she was doing. Now, again, as I stated, there are no explicit outside of our standard legal remedies for, assault or whatever have you. There is no explicit protection in our state constitution, let alone in our statutes that protects her. However, had they have been found guilty, or if we can make the argument that they were intimidating voters, there are protections. So there are things that we can do if they are assailing individual voters. There are things that we can do quickly too, in advance of that, to ensure that voters feel comfortable. Now, that being said, a lot of that involves communication and willingness on the part of law enforcement to be engaged early in the process. We have found that in some cities, they're more than happy to do that. And others, they're a little bit more resigned to whatever happens, and they'll show up after the fact. So I think it is incumbent on those chief election inspectors to both make sure that them and their clerks are in early communication with law enforcement, so that there's a plan in place in advance, and then try to make sure that that information gets up the flagpole as quickly as it can. Because if they do, we can ensure that there's something that happens to protect them, but also something that happens after the fact. So that is important. Yes, ma'am.
Who would you trust to draw fair maps?
I have an idea, but I'm trying to figure out how much TR can say and how much Law Forward can say, and that's always a tough balance. TR would say that in general, I think we have enough systems, i.e. computer systems, that exist now and that continue to be created that can create hundreds of thousands of maps in virtually an instant, that there is very little reason other than to make tapers around the edges to have much human involvement. I think in general, people will always be inclined to preference their interests. Law 4 would say whatever the process is that we decide on as a group in our state, hopefully in legislation that comes out in early January next year, that will be the process that we will protect and try to make sure works for the best of all people in Wisconsin going forward.
Along with that, the last two elections, actually, the voters didn't even matter. It was a done deal before the first vote was cast.
Yeah, I would say more than 2 elections. I would say at least, again.
Okay.
But you're absolutely right. And that is, to me, why the hand of individual legislators probably isn't the right place to go in a society that's as polarized as we are right now. And I would also make the argument that the gerrymandering we saw is a good reason why we experience the polarization that we do. Like gerrymandering isn't, especially when it's one party against another, gerrymandering isn't just bad for the party that's not in favor. It's bad for the party that is in favor, because what it does is kind of inculcates an environment where you get the most extreme ideas in one direction or another. So you lose the integrity, but also you lose the novelty in moderates. You lose the idea of compromise, and you harm democracy as a result. And I think a lot of what we see today is as a result of what happened at Michael Best and Friedrich 13 years ago. So 100%.
You mentioned the women.
Yep.
What other organizations that share this part of the mission, and how do you coordinate with that?
So that's a great question. Unfortunately, in our state, because we are a swing state, I'm not gonna say unfortunately, because it's a great thing. It gets a lot of people jobs and whatever have you. But we get a lot of people in election years that just kind of come in from anywhere else, DC, California, New York, wherever else have you, that come in and try to engage and educate our voters. And while I applaud them for seeing the value of Wisconsin and our democracy, we also really need to understand that the people who have the best interests of Wisconsin at heart are going to be the people that are here. So the League of Women Voters, absolutely a great partner. There are other partners like Block, NAACP, Expo, which is the long and the short of it is Return Citizens Coming Home and their efforts. But there's also the Civic Engagement Power Table. Now, what that is a replacement for what was the Wisconsin Voices Coalition. So it was a group of nonprofit organizations that operate in our state that have an interest in making sure that the public is informed and participating in elections. So this group of, I think it's like 69 state-based organizations that do various different works to educate voters. We sit in on those tables so that we make sure that we're hearing from them and that they know how to engage us as well. So we do work outside of just the courtroom to ensure that we're as plugged into what's happening in Wisconsin as possible. Yes, sir.
Is Law Forward a nonprofit?
Yep.
Organization?
Yep.
And you accept donations?
Yes, sir.
Are your 5 lawyers, do you have other work as lawyers elsewhere?
No, this is our full-time work, for better or worse. My student loans would say worse, but the reality of it is the work itself is integral to who I am as a person, and is why I do it. Like, I came to Law Forward because it was the nexus of everything that I had done before law school and the things that I believe in going forward. And I think that'll continue to be the case. My hope is that we'll get more involved in different aspects of democracy going forward. Like I said, a lot of our work has been central to like election integrity protection, election protection and access, as well as accountability. But I'm hoping that we can do more social justice work as well. So this is my vision. One second.
I recommend everybody donate to Law Forward, and I also recommend that Milwaukee County, not just the league,
Yep.
but League of Women Voters Milwaukee County. And I'm the membership chair, so I'd be glad to start anyone that.
Yes, sir.
Just to clarify, you are a 501c.
Yes, sir. Yes, sir.
Can I, let people know that the prison in Wisconsin, those prisoners are counted as members of the community.
Yeah, I didn't put it up here, but so when I say I want to get more involved in some of the social justice work, both prison ballot access, which is a problem. So there are people that are in jail that still have the right to vote that have not been because for whatever reason, the people that are in charge of those facilities don't often provide that information to those individuals who are most subject to what happens in our government. But another primary issue is that idea of prison gerrymander and how it is one of the other tools used to systematically dispossess the people in large areas of the power that they should have electorally as well as in terms of resources. So that's a great point, sir, and one of the things that I'm very passionate about. Yes, sir.
You mentioned Pence before. Didn't they try to get some law or some kind of amendment or something so it was absolutely clear that the vice president's position was just
Ministerial.
in terms of approving the vote?
So following the 2020 election, there was legislation that went in both directions. In a lot of the state houses, we saw states that are led by, and I think it's 32 states that are led by Republican leadership right now. Good number of those tried to make efforts to create a separation between what happens in the popular election and what happens with their electors. So basically giving freedom to the state legislator to dictate or decide how the electoral votes of that state go. So that's one movement that was happening. But at the federal level, there were different pieces of legislation that were proposed that would have clarified that the vice president's role is strictly ministerial. Unfortunately, that did not pass. So we are still in a situation where in 2020, now I'm sure they didn't want to give that power to Kamala Harris, but that is where we're at right now, where there is an argument that some crazy people make. It's called the independent state legislature theory that allows him to function or allows the vice president to function in the way that they see fit based on what happens at the state level. So yeah, you're right. It was proposed, but it did not take shape. I'm pretty much ready to wrap up, but if there are more questions or people have more statements, I am here. It was definitely a pleasure speaking with everyone, and I thank you for your time.